These are the developments we've seen in the days since the USCIS policy announcement on May 21st and how we are advising our adjustment of status clients today. May 21st, USCIS officers received a policy memorandum stating that if someone originally entered the United States as a non-immigrant with permission to be here only temporarily, but later applied for adjustment of status to live permanently in the U.S., they had to provide evidence of positive equities in the U.S. to outweigh the negative factor of not having complied with the terms of their admission as a non-immigrant. The policy was delivered to the officers on Thursday and to the public on Friday. Friday, we had an application for adjustment of status approved for someone who had overstayed a visa and had not provided any additional evidence of positive equities. After the Memorial Day holiday, we had another application approved on Tuesday for someone who had overstayed a visitor visa and then later applied for adjustment of status. We started to see changes take effect on Wednesday. First, when an immigration officer asked an adjustment of status applicant 3 questions. Why did you overstay your visa? When did you decide you were going to overstay your visa? And why can't you become a resident through an interview at the U.S. consulate in your country of citizenship? Also on Wednesday, we received a copy of a letter given to an immigrant by a USCIS officer with a list of the type of evidence that should be provided to outweigh the negative factor of having overstayed the visa. On Thursday, we received word from an attorney in Chicago that an officer said that she could approve a family-sponsored petition that was not able to make a decision on the adjustment of status application until a supervisor had reviewed the case and the officers were still awaiting guidance as to how to handle the new policy memorandum. Then on Friday, there was an article published by the New York Times saying that USCIS officers said that not everyone will need to return to their country of citizenship to become a permanent resident, and that cases would be reviewed individually to determine whether or not someone deserves to have adjustment of status as a matter of discretion. The policy announcement from May 21st, 2026 has not changed. Cases will be reviewed on a case-by-case basis. And as we presumed, having read the memo, not everyone is going to have to return to their country of citizenship to apply for their permanent residency. But absolutely, anyone who entered the United States as a non-immigrant, promising to return to their country of citizenship after their permission to be here had expired, must provide evidence of the positive reasons why they should be permitted to remain in the United States rather than to have to leave the U.S. We're advising all of our clients who meet the basic requirements for adjustment of status to submit their applications. Once their applications are submitted, they are considered to be lawfully present in the United States, but to also work on a supplemental filing to their application showing all of the positive equities about their life in the U.S. and a request for the officer to exercise discretion favorably and approve their adjustment of status so that they will not have to leave the U.S. to become permanent residents.